8239, or you can use the question and answer box, and one of our staff will assist you. I want to let you know that all attendees that signed in today are in listen-only mode, which means that we can't hear you when you're speaking, but you may ask questions and you may submit them at any time during the presentation. If you want to ask a question, you can use the question and answer box on the right side panel. This is what it looks like. You can type your question into the small dialog box and then make sure to click the send button. Only the panelists can see your questions. I want to take a minute to tell you a little bit about the National Center's DNA Resource Center before I turn the webinar over to our presenter. The National Center's DNA Resource Center's goal is to increase understanding about how we can solve more crimes and prevent more crimes by increasing the use of forensic DNA and DNA databases. I want to thank our sponsor, Life Technologies, who has long supported our work in this arena and continue to support our DNA Resource Center. With their support, we have conducted many webinars, lots of in-person trainings across the country, and we're bringing a couple more to different communities this fall. We've developed materials about forensic DNA for victims and for law enforcement professionals who work with victims. All of that is available on our DNA Resource Center online. Here's the address. We have more than 15 archived webinars there for you to view. And those range on topics from using DNA in burglary cases, local DNA databases, using DNA in missing persons cases and trafficking cases, and many, many more. And one recent one coming up, one that will be coming up soon, our next webinar will be on September 16th. This will feature Representative Smith from Nevada, who will discuss how they overcame some barriers and challenges to passing a DNA at arrest collection law. So you can look for that announcement on our website. Here's my contact information in case you want to email me with any suggestions or questions, or just tell us generally how we're doing in our work with these webinars. And we also are on Twitter, and I think that was on the scrolling slides at the beginning, but our Twitter handle is @DNAAnswers if you want to follow us on Twitter. Okay, so now on to our main event. We are thrilled to have Michael Green here with us today. Mike is the Executive Deputy Commissioner of the New York State Division of Criminal Justice Services. Prior to joining DCJS in March 2012, he served as the Monroe County District Attorney for 8 years and was an Assistant District Attorney in that office for 17 years prior. He has handled more than 100 jury trials, including 40 homicide cases. I'm very, very interested in hearing what he has to say about misdemeanor DNA collection. It sounds like they're doing great work in New York. So I want to thank you, Mike, for taking the time to tell us about how New York State's Databank is solving crime.
Thank you for the introduction, Elsa. I appreciate it. My talk today is DNA Stops Crime, the case for misdemeanor DNA collection. New York State's DNA database began in 1996. At that time, DNA samples were collected from individuals convicted of homicide and certain sex crimes. It was a very limited database when it started. The database has been amended 5 times since the inception in 1996, each time expanding the number of crimes that require a DNA sample upon conviction. That is something I wanted to note. All of the expansions required conviction, and currently the database is still only upon conviction. Now, prior to the most recent expansion in 2012, DNA samples were taken from individuals who were convicted of penal law felonies or one of 36 different penal law misdemeanors that were enumerated in the statute. Even with that group of crimes, we were only collecting DNA samples in New York at that time from about 48% of the offenders convicted of penal law crimes. So even with all felonies and 36 enumerated misdemeanors, we were still failing to collect DNA samples from more than half the people convicted of penal law crimes. The DNA samples were taken from convicted offenders not only pursuant to convictions for those enumerated crimes, but also under something called our subject index regulation. Subject index submissions were samples that were collected and still are collected in a number of different situations. One situation is where there's a plea agreement. As part of the plea agreement, the prosecutor, the defense can agree that one of the conditions of the plea offer will be that the defendant agree to submit a sample for the subject index database. Some other reasons would be, for example, as a condition of participating in a state prison temporary release, a comprehensive alcohol and substance abuse treatment, or a shock incarceration program. The Department of Corrections would make the submission of a DNA subject index sample a condition of participation in those programs. The Department of Corrections has also made submission of a subject index sample a condition of release on parole, on post-release supervision, presumptive release, or conditional release on a definite or an indeterminate sentence. And finally, probation departments have made the submission of a subject index DNA sample a condition of probation or a condition of interim probation supervision. So those subject index samples would be in addition to samples submitted from people convicted of enumerated crimes in the statute. What our experience in New York has shown is that offenders don't specialize. Research that we've done shows that offenders who commit serious crimes also often commit minor crimes. For example, petit larceny, which in New York is theft of property worth under $1,000, so most commonly shoplifting, became a DNA eligible offense in 2006. Since that time, defendants who are convicted of that misdemeanor crime have been linked to over 1,000 crimes, and they included 457 burglaries, 238 sexual assaults, 137 robberies, and 57 homicides. So again, just proving the point that there is overlap between people who commit serious crimes and people who commit, I hate to say minor crimes, but lesser crimes. Now, looking at a couple of case studies that illustrate that point. The first is Raymond McGill. And I should say before I get into this case study, I made reference to the 2012 expansion of the DNA database in New York State. And what the 2012 expansion did, and I think we'll get to more of it later, is that expansion required almost everyone convicted of a penal law crime, whether it was felony or misdemeanor, to submit a DNA sample upon conviction. But back to Raymond McGill. In January of 2000, an elderly woman was raped in her home, and the perpetrator's DNA was left at the scene. About 2 months later, still in 2000, another woman was raped and murdered in her home. Now, fast forward 4 years to January of 2004, another man was found in his home, beaten and shot to death. DNA at each of those scenes matched the same unknown assailant. In March of 2005, Raymond McGill was convicted of attempted robbery, unrelated to any of the above three crimes. That crime in 2005, attempted robbery, required him to provide a DNA sample upon conviction. So upon his conviction for attempted robbery, the DNA sample was collected, it was entered into the database, and that sample linked him to the three unsolved crimes. Now, prior to the attempted robbery, McGill had been convicted of 2 minor crimes. Back in 1999, he was convicted of petit larceny, and he was also convicted of a misdemeanor drug possession charge in 2003. Unfortunately, neither of those crimes at the time required a DNA sample upon conviction. Had his DNA sample been convicted after the petit larceny conviction in 1999, the January 2000 rape would have been quickly solved, and the 2000 and 2004 murders likely would have been prevented. The misdemeanor drug possession charge, of which McGill was convicted of 3 months before he killed his second victim in January of 2004, only became a DNA eligible crime with this most recent 2012 expansion. So the good news is that McGill is currently serving a prison sentence of 40 years to life based on his convictions. The lesson learned, though, is that had we had all crimes DNA, or a requirement that everyone convicted of a penal law crime provide a DNA sample for the database, a number of very serious crimes could have been prevented, and certainly the first rape could have been solved much quicker. Unfortunately, that's not the only example. We have a number of examples like that. Another example involves Francisco Acevedo. 3 women were murdered in Yonkers, which is a community just outside of New York City, just north of New York City, between 1989 and 1996. Evidence was collected at the scene of each of those murders. That evidence included evidence which could be analyzed for DNA. DNA profiles were obtained, and the 3 murders were all linked to the same individual. A DNA profile from the crime scenes was entered into the DNA Databank in 2002. 7 years later, authorities in Westchester County, the county where Yonkers is located, were notified of a match, that the offender was a serial DWI offender who had been required to provide a DNA sample in New York State as a condition of his parole. So that was one of the subject index situations that I spoke of earlier. So it was only when parole, as a condition of his release on his DWI offense, made him submit that sample that the comparison was done and that he was linked to the 3 murders. In November of 2011, a jury deliberated for fewer than 5 hours before finding the defendant guilty of all 3 murders. He's now serving 75 years to life in state prison for those crimes. I think the common thread there and the lesson that we've learned over and over again is that offenders linked to crimes through the DNA Databank had, on average, committed 3 offenses for which no DNA sample was required prior to the time that they committed the offense, that they were convicted of the offense that they were required to give the DNA sample on. An analysis of our DNA Databank hits in New York showed that if all crimes DNA had been in effect, so everyone who's convicted of a crime had to give a DNA sample, nearly a quarter of our hits to the databank would have occurred an average of 5 years earlier, resulting in leads in over 47 homicides, 125 sexual assaults, and 2,313 other offenses. Another example is Kenneth Washington. Back in August of 2006, an off-duty New York Police Department officer woke up at 2 a.m. to find an intruder in her bedroom. He raped and physically assaulted her. He left a bloody T-shirt and his DNA at the scene after the attack. Now, Kenneth Washington had been convicted at that time of 2 misdemeanors, including a criminal trespass prior to that rape. However, his DNA was not in the state's DNA database because those misdemeanors at the time were not DNA eligible. For the next 14 months, Kenneth Washington went on to commit more violent crimes. He sodomized a pregnant woman. In a separate case, ransacked another home, stealing a family's Christmas presents, and bound and tortured a family during another burglary. He was finally linked to those crimes after being required to provide a DNA sample for a low-level assault conviction. Had his DNA been collected after the first criminal trespass conviction, he would have been caught as a result of a comparison through the DNA database after the first rape he committed in August of 2006. And the 3 crimes that I mentioned above would have all been prevented. So again, the good news is that he's now serving 90-year prison sentence for his crimes. The lesson learned is that had we had an all-crimes DNA statute in effect, we would have prevented 3 very serious felony crimes from taking place. This example is one that unfortunately is near and dear to my heart, and this involves Keith Laster. I was an assistant district attorney and ultimately the district attorney in Monroe County and held those roles for about 24 years. Back in 1995, there were a number of rapes in Monroe County, but 3 rapes in particular that were dubbed the Schoolgirl Rapes, and they got a lot of attention. They involved 3 young girls between the ages of 10 and 13 who were all on their way to school in the morning or waiting at the school bus in the morning when they were raped, brutally raped. Those cases were all unsolved. And in fact, in 1995, there was a task force formed by the police to investigate the crimes. I was assigned as an assistant district attorney to work with the police on that task force. Rape kits were collected in all 3 of those cases. When those rape kits were tested, identical profiles were obtained in each case, indicating that there was one rapist responsible for those 3 cases. A year later, in 1996, Keith Laster was arrested and convicted of 7th-degree criminal possession of a controlled substance, which was a misdemeanor. There was no requirement at the time that he submit a DNA sample for that conviction. Obviously, if there was, he would have been linked to the 1995 rapes. The rapes were quiet for about 2 years until 1997. And in 1997, a 13-year-old young girl left her house on the same street where the misdemeanor drug conviction happened, walked to the bus stop at the end of her street. She got within 1 house of the bus stop. She was grabbed, dragged behind the house, brutally raped, and about 7:30, quarter to 8 in the morning, went running home to her mother, bleeding, crying, after having been raped by Keith Laster. Again, in connection with that case, a rape kit was taken, a DNA sample was developed. That case was linked to the prior 3 1995 rapes. But again, there was no, the cases were put into, or the profile was put into the database, but there was no sample to hit against. There was nothing on that case until 2004. In 2004, I was the DA. I remember getting a call in my office telling me that through the national database, we received a hit from a case in Alabama, and it was actually an investigation in Alabama. The hit we got was from a profile from a rape kit, from a rape in Alabama that had been put in. That hit against our 4 open cases from our 4 rape kits, from the 395 and the 97 rape. And basically when we called Alabama, they indicated that they knew who the suspect was, and ultimately they took a sample and confirmed that it was Laster. Laster, obviously his DNA matched the 4 rapes we had. That misdemeanor drug possession that he had in 1996 was not a DNA-eligible crime until the 2012 expansion of our DNA database. So Laster was brought back to New York. He was tried, convicted, received a life sentence, and that was in 2005 or 2006. But for the next 4 or 5 years, New York continued to have a statute where if that same scenario had repeated itself, we would not have been able to prevent that last rape. We also noted that the most common expansion crime now for which DNA is taken upon conviction, and it's about 30%, is a misdemeanor drug possession. Now, just to go over some statistics or outcomes from our New York State database, August 1st of 2012 was when our all crimes DNA went into effect, requiring anyone convicted of a penal law felony and almost everybody convicted of a penal law misdemeanor to submit a DNA sample upon conviction. So in less than a year, we looked at the results. We have a total of 476,932 unique offender profiles in our database. That's 10% more than a year ago. Some of that 10% is obviously samples that were submitted pursuant to the expansion of the database. There are also about 43,942 forensic profiles in our database, about 10% more than we had 1 year ago. If you look at hits against our database by crime type, through June 30th of 2013, there have been a total of 12,947 hits or investigative leads against the databank since its creation. Now, of those, almost 89% of those hits linked offenders to one of 4 crimes. The most common was burglary, and we've had 4,492 hits linking offenders to burglaries. Second was sexual assaults. We've had 4,058 hits linking offenders to sexual assaults. Third was robbery. We've had 1,508 hits linking offenders to robberies. And fourth was homicides. And we've had 1,038 hits linking offenders to homicides. Looking at statistics specifically related to the 2012 expansion of the DNA database, from August 1st, 2012 through June 30th, 2013, 17,545 samples were added to our database as a result of expansion crimes. So previously we were collecting samples from about 48% of our convicted offenders. Now we're somewhere in the neighborhood of 99% of our convicted offenders, and it's resulted in 17,000 more samples. About 87.4% of those samples, or 14,412, were taken as a result of convictions to 10 crimes. And those crimes most commonly were misdemeanor drug possession, criminal contempt, which is generally violating an order of protection issued by a court, driving while intoxicated, and criminal mischief, which in New York is damaging property. If you look at the hits against the DNA database by crime type, since the August 1st, 2012 expansion through June 30th, 2013, there have been 216 hits to the DNA database that resulted from samples that were given by people who were convicted of a crime that first required a DNA sample to be submitted as a result of the 2012 expansion. So again, generally those are people convicted of misdemeanor crimes, and those hits linked people to burglaries. We have 90 hits linking people to burglaries, 54 hits linking people to sexual assaults, 17 hits linking people to robberies, 15 hits linking people to larcenies, and 13 hits each to homicides and assaults. And again, this goes back to a point I made earlier. Some people argued when we were trying to get the expansion of the DNA database passed that if you collect samples from people convicted of lower-level misdemeanor crimes, all you're going to get are hits to lower-level misdemeanor crimes. And obviously this data proves that that's not true, that the samples we're collecting from those lower-level crimes are generating hits to significant felony cases. In terms of tracking outcomes, at this point it's really too early to give you outcomes like we were able to do with some of the prior expansions and let you know what happened to those cases. One of the reasons is, as everyone knows, a DNA hit is only a lead. It's a lead that needs to be thoroughly investigated like any other lead. We are working with the district attorneys in our state. We have 62 counties in New York State. Each one has an elected district attorney. We're working with each of those offices in developing a systematic tracking system so that we can develop, or we can track the results of all of those DNA hits or leads that we generate. What we do know, though, is that the law will result in fewer men, women, and children being victimized, fewer individuals being wrongly accused, and those who commit crime being brought to justice sooner. Now, as far as the 2012 databank expansion, I'm going to talk about some exceptions to the expansion. I'm going to talk about some things that the expansion did in terms of defense access to DNA and I'll talk for a minute about some safeguards. In terms of exceptions, I indicated earlier that the expansion made a requirement that almost anyone convicted of a penal law felony or misdemeanor provide a DNA sample. Some of the cases that do not require submission of DNA samples are, first, children involved in family court matters. In New York, those aren't classified as convictions, they're adjudications. The second is youthful offenders. New York law is different than the law in most of the rest of the country in that regard. 16 and 17-year-olds in New York, their cases are still handled through adult criminal courts as opposed to a family court. However, in many instances, they're eligible to be adjudicated as youthful offenders instead of being convicted of a crime, particularly on their first conviction. So those youthful offender adjudications do not require the offenders to submit DNA samples. The other major exception was first-time offenders convicted of a specific subsection of our penal law that related to possession of marijuana in a public place. So if you were convicted of fifth-degree marijuana possession under that specific subdivision and you had no prior convictions, you were still not required to submit a DNA sample. It sounds like a wide net when I describe them, but it really is a very, very small percentage of our offenders. And so now with the 2012 expansion, almost everyone convicted of a penal law felony or misdemeanor has to provide a DNA sample on conviction. The law also provided defense access to DNA testing, or I should say expanded defense access to DNA testing. In the new law, significantly expanded defendants' access to DNA, both testing and comparison, both before and after conviction in appropriate circumstances, and also dealt with discovery issues, expanding access to discovery after conviction where the defendant raised a claim that he or she was actually innocent. Now, prior to trial, the law was amended to allow defendants in certain criminal cases to obtain DNA testing to demonstrate their innocence. Generally, prior to that change in the law, the decision as to whether or not to submit things for DNA testing was made by police and by prosecutors. After this expansion, defendants in certain instances have the ability to make a motion and ask the court to order testing in certain instances. After trial and after conviction, defendants are now able, given this new statute, to seek discovery of property and other materials that will demonstrate actual innocence after their conviction. And that discovery can provide the court with evidence necessary to make a decision on a defendant's motion for such relief, and in appropriate cases to order DNA testing post-conviction. One of the important things to note with that subdivision, that did not apply retroactively. So it applied to cases which took place from the effective date of the statute going forward. The law also made certain provisions with regard to expungement. The expungement of DNA records is authorized under New York State law. Since the inception of the databank in 1996, there have been 232 expungement requests, and 183 of those records have been expunged. Now, with regard to safeguards, there are a number of safeguards, and one of the things that's always debated anytime there's a proposal to expand the DNA database is whether or not there are violations of people's privacy, whether or not there's sufficient safeguards in place. One of the main safeguards is it's a felony in New York, punishable by up to 4 years in prison for anyone to intentionally disclose a DNA record, tamper with a DNA sample, or use test results other than those authorized by law. In addition to the criminal sanctions, the process by which DNA profiles are uploaded, tested, and matched to convicted offenders ensures that nothing other than science affects the outcome of a match. The DNA profiles are kept as numerical sequences, unique to each offender. There's no genetic material that's actually stored in our DNA databank. Names, photographs, and criminal history records that correspond to DNA profiles are not maintained in the databank. And the State Division of Criminal Justice Services, or DCJS, the agency that I run, is the agency that confirms the identity once a match has been made. However, DCJS does not have access to the DNA profiles maintained in the databank. Those are maintained by the state police. So once a DNA match has been made, confirmatory testing is done to ensure its accuracy before local labs and law enforcement personnel are notified. I should also note that that notification that goes out to local law enforcement and local laboratories indicates specifically that the information being provided is an investigative lead, and before any action is taken on that investigative lead, independent testing should be done at the local level to confirm that match. Now that concludes the formal part of my presentation. I'd be happy to answer any questions if we have questions.
Hi, Mike. Can you hear me?
Yes, I can.
Hi. It looks like we're having some technical difficulties here, but I have some questions for you.
Sure.
Wouldn't you get relatively the same percentage of hits if you made every citizen submit DNA? Meaning there isn't a relationship between someone who has not committed a crime?
I suppose arguably if you made everyone submit a DNA sample at birth, you would get more hits. You would get a much higher percentage of hits. The debate, at least in New York, has always centered around issues like privacy. There's been arguments about infringement on privacy, and how do you balance those concerns? And everyone seems to attach different weight to them. The way New York has chosen to strike that balance is, say, at the point in time when you are convicted of a crime, and we've now gotten to the point, as I just explained, where it applies to almost every crime. When you're convicted of a crime, the state's right to have that profile outweighs that privacy interest. Now, obviously, the U.S. Supreme Court has weighed in and indicated that in at least some circumstances, under some conditions and with appropriate safeguards, some pre-conviction, post-arrest DNA collection is okay.
Right. And what is the criteria for expungement of DNA records?
Yeah, I don't have the statute in front of me. I can get that. But certainly situations where, for example, a conviction was overturned on appeal, and there's no other eligible case for someone to be in the DNA database.
All right. Are the profiles in the subject index uploaded to NDIS or maintained at the state level only?
Both. They're maintained at the state level, and then they are run against it. I take that back. I was thinking the database as a whole. The subject index database, I believe, is just maintained at the New York State level. I believe it is just our, the database of DNA samples are provided on conviction that are uploaded to the federal level.
Gotcha. How much does it cost to get the DNA analysis for one person?
You know, there's so many variables that it would be hard to give you an exact price. I think that the best I could do is tell you that the kits that are used cost about $30 per kit. So in terms of hard cost, you know, but depending on who's making the argument, you know, how do you factor in the time of the person who takes the swab? And, you know, so it's very difficult. But the kit itself, which is probably the most concrete cost I could give you, is $30.
Great. To what extent does the rape victim have the legal standing to go to court to require investigators to test and compare their collected DNA evidence when there has been no suspect otherwise identified?
And they really don't have standing to do that in New York. It's, you know, there is no provision in New York law. You know, generally prior to an arrest and a prosecution, that decision lies with the police and prosecutors. As I indicated in my presentation, once, you know, if there's an arrest and a prosecution, in some limited instances, the defense can seek testing, but there really is no standing on the victim's part to get testing.
Is the DNA search in your local database similar to a CODIS search with stringency and misses, or are you only looking at the perfect match level?
I guess I'm not exactly positive what you're asking. We are, generally speaking, perfect match level. There is a partial match policy with regard to inadvertent hits, but generally speaking, it's perfect matches.
Right. Did you send me other questions? Oh. What was the support level of the law enforcement officers' willingness to collect these types of samples before and after the law was passed and these results were obtained?
Generally, law enforcement has been extremely supportive, you know, particularly police departments, sheriff's departments. In some isolated instances, there have been challenges in terms of the, you know, resources, who's actually going to do the collection. You know, for example, we track collection rates, so we know that this group of offenders has to give DNA samples on conviction. So we track to see what percentage of those we're actually getting samples from. A certain group of offenders get sentenced to prison or jail, and the collection rates are very high for that group, you know, usually around 99%. Obviously, it's a, you know, no pun intended, but a captive audience. It's much easier to collect samples. The second group that we look at are people who are placed on probation. And again, our collection rates for that group are usually very high, and the burden generally falls on probation officers to collect those samples, and those are generally in the high 90s. The third group we look at are offenders who are sentenced to other sentences other than jail, prison, or probation. So people, for example, who are given a conditional discharge or an unconditional discharge and are not under any type of supervision. In some of our jurisdictions, court officers collect those samples, and so the samples are collected before the offender ever leaves court. And in those places, obviously, the collection rates are very high, and we get samples from 98 or 99% of the offenders. Unfortunately, in other jurisdictions or other counties, offenders are told when they receive a conditional discharge or an unconditional discharge to report to a police station or a sheriff's station to provide a sample. And they actually leave court, they go out, and they have to report. In those cases, our collection rates are somewhat lower. Sometimes we have collection rates in the 80s on that group of cases, just because you have a certain group of offenders who don't come back to give the sample, and then law enforcement has to actively go out looking for them. So that's been a challenge, trying to get all of the samples collected before an offender leaves court. We do have collection rates overall that are in the 90s now, but they're not at 100%, so it's a challenge and it's something we work at. And we track it at the Division of Criminal Justice Services, county by county, and then in each of those three categories. And on a regular basis, we send results back to every county detailing for them how they're doing on their collection rates, so they can see how they're doing, how all their other counties are doing, and if they need to work on particular collections.
All right. Under what authority are the subject index samples collected? That is to say, is it New York state law or something else? And if it is state law, is there a reason that these samples aren't put into the legal index and uploaded into NDIS?
It's not under state law. There's a state regulation that provides for it, and I think that's one of the reasons why the samples are not uploaded. And generally, the theory behind the regulation is consent. For example, when there's a plea agreement, the defendant doesn't have to enter into that plea agreement, but the prosecutor and the judge indicate that if they do want to enter into that plea agreement, as a condition of the agreement, they have to consent to give a sample. The same thing with the releases that we talked about with regard to people being released on certain types of temporary release or work release. Generally, those are discretionary calls as to whether or not an inmate gets released. And so as part of making that discretionary call, one of the things that's looked at is whether or not the person's willing to provide a sample.
All right. If DNA was not found in the databank, how would a crime be solved if the DNA is not found? That's
the challenge. In many instances, unfortunately, the answer is it's not solved. And that, the examples that I went through in my presentation, until we started collecting DNA for all crimes, or almost all crimes, we had a number of offenders who were out there actively committing crimes who had been convicted, but never convicted of crimes that required them to give a sample. And unfortunately, their cases weren't solved until they got to the point where they were required to give a sample. So the first answer is that if there's no sample in the database, in many cases, unfortunately, that crime won't be solved. And secondly, if and when in the future that person is convicted of a crime that requires them to provide a sample, then hopefully those connections would be made through the database and those crimes would be solved.
What are your thoughts on arrestee legislation now that the Supreme Court has upheld its legality?
Certainly with the proper safeguards and under proper circumstances, the Supreme Court has said that it's legal and it can be done. And I think I know there are examples where it can be a powerful tool, both in terms of the investigation of the case for which the person gave the sample and also solving other cases sooner. Now, if you look at just the New York experience and the time from arrest to conviction, depending on where you are in the state, some places arrest to conviction can take place in 6 or 7 months. Other cases, unfortunately, it can be as long as 3 years. If the person is not in custody during that time, waiting 3 years until there's a conviction and until you can get a sample, provides someone with the opportunity to commit additional crimes and certainly delays the opportunity to solve crimes from forensic samples that are currently in the database.
Right. right. How many samples on average do you have to test in a month? And what's the turnaround time for testing?
I can tell you the turnaround time is about 37 days for the offender samples. So if someone's convicted, the sample's taken, it's about 37 days before that sample's analyzed, the profile's developed, and it's put in the database. I believe there's approximately 7,000 samples per month that are collected and analyzed.
Who collects the subject for a misdemeanor crime where the penalty is just to pay a fine? Does the bailiff collect those types of samples?
And that's what I was indicating earlier. In some jurisdictions, our court officer, which I think is, or court deputy, which is what they're referring to as a bailiff, does collect the samples. Now, obviously, that we tend to get higher collection rates in jurisdictions where that's the case, because more often than not, you will get the sample collected before the offender leaves court. In other counties in the state where that doesn't happen, offenders are told that they have to report to a police station or a sheriff's station to provide a DNA sample. And there, our collection rates are somewhat lower. And some of them, they're down into the 80s in terms of percentages of offenders we're getting samples from. Because once the offender walks out the door of the courtroom, our experience is that there's a certain percentage of offenders that are not going to go back and follow through and report to the police department or the sheriff's department to give a DNA sample. And then the police end up either trying to track them down or waiting until they're rearrested if they can't track them down to get the sample.
Do you anticipate seeing, or have you seen where the refusal to supply a DNA sample becomes part of an accepted plea bargain?
No, well, the beauty now with the statute, since it's been expanded in 2012 to include almost all penal law crimes, is that that's just not an option. It's a legal requirement that a person provide a sample. So, you know, if we have not had a case where anyone's tried to avoid that legal obligation, and if they did, I would think any agreement where a judge agreed not to order that, it would seem to me could be challenged and struck down is unlawful, you know, because there is a legal obligation upon conviction for those crimes now. Previously, when you were relying on people's consent in regard to the subject matter index, yes, that was a problem. If you had a problematic case and the defendant said, if you require me to do that, I'm not going to plead guilty, you know, one of the risks would be that the prosecutor or the judge would say, fine, I'll take the plea and I'm not going to require the sample to be taken. So that's a major advantage to having legislation which requires the DNA sample be provided upon any conviction for a crime.
What percentage of your offender samples are duplicates? And is there a way or a method in place to reduce duplicate submissions?
Yes, that has been an issue that we've dealt with here in New York. And initially, the legislation wasn't clear. Our position at DCJS, reading the legislation, and ultimately we did get a court decision that supported that position, was that if the offender sample was already in the DNA database, we would not process the duplicate. In rough terms, I think it's approximately 17% of the samples that come in now are duplicates. Prior to the expansion in 2012, it was about 10%. So you can see as we expanded the group of people that had to give samples, there is more overlap with people who are already in the database.
And how big is the staff that handles the 7,000 samples a month?
In that, I don't have exact figures for you. It's the New York State Police Lab that actually handles those samples, not the Division of Criminal Justice Services, so I can't give you a number offhand. It is a highly automated process to handle those samples.
All right, I'm not seeing any more questions in our Q&A here. So I'm sorry for this little bit of chaos here at the end and change in presenter. But if everyone would please fill out our evaluation, and the recording will be available on our website in a few days. And I'd like to thank Mike Green for his taking the time to speak with us today and for his wonderful presentation. Please email us if you want to get our email announcements. I have Ilsa's contact information up here on your screen. And thank you all very much for being here. Do you have anything else, Mike?
No, thank you. I think it's a very informative program. I appreciate the opportunity to present.
Great. We appreciate you being here. Thank you very much. And thanks, everyone, for attending.